So thank you for coming out and being part of our conversation. Lot to cover. We've got about I can go over, right? I can stay a half an hour. Okay, good. That's my prerogative as moderator. I would love it actually if you could, before we get into the details, just step back and scene set the big picture here in terms of where we are in the antitrust discussion. I mean, there has been a historic amount that's happened really in the last couple of years. And so if you had to sort of pull back and give us your big picture look of where we've come and where you think we're going in the next few years, that would be great.
Sure. Can you guys hear me well? Yeah. Thank you so much to the Open Markets Institute for having me. And thank you, Rana, for this, what I'm sure will be fabulous conversation. So to scene set a little bit, since the 1980s, really the 1970s, but sort of hastening in the 1980s, I think you start to see a more permissive approach to antitrust enforcement and business consolidation and business conduct. And the consequences of that, I think, have only recently started to come into full focus. So again, you have decades of really low monopolization enforcement, more consolidation, and even when law enforcers, including at the DOJ and the FTC, had concerns about mergers that raised competition issues, you started to see consent decrees and settlements that, even by the admission of some of our predecessors, really were not uniformly upholding competition, and some of which failed in ways that are really striking. And so there's been more of an interest in antitrust issues recently. And I think the reasons for that are perhaps debated, but you do see more concern about things like income inequality. You saw a two-tiered recovery from the 2008-2009 financial crisis. The Council of Economic Advisors under President Obama documents that there are concerns about wage stagnation and new business formation that's down. There's a growing body of research that new business formation is down actually 50%, that 75% of industries are more consolidated, that there's been an increase in markups by nearly 40% in really important industries like retail and healthcare and agriculture. And so you also see more interest across a political and ideological spectrum. You see concerns about censorship. You see concerns about deplatforming. You see concerns about choke points to the very information that we consume. And whether you think any of those concerns are legitimate or not, they kind of bring people to heightened interest about antitrust. And I say this a lot in my public speaking. Someone much smarter than me once said that Americans look to antitrust when we are uncertain about the future. And it's a really interesting time to be in the agencies and to be thinking about the anti-monopoly and antitrust tradition and what it means to really revive that.
That's really, I love the idea of looking to antitrust in a time of uncertainty, which, I mean, honestly, since I've been doing my job for 33 years, I don't think there's ever been a period economically where there were so many different vectors, change vectors in play. And we've been talking about technology today, but there's the capital labor divide, there's growing inequality and the ramifications for the economy, there's demographic shift, monetary policy. So it's really apropos of what you just said. It's interesting to me too, and actually we're going to drill into AI in a moment, but the fact that the president's EO specifically called out competition as one of the ways to think about and deal with the AI problem is very telling, and it kind of mirrors so much of what he's done, looking at competition as a way of fixing government and fixing our economy. So you guys have your hands full, I guess, is the bottom line here. But let me ask you another big picture question. Something we've been hearing about for some time is that the FTC and the DOJ are rethinking and rewriting merger guidelines. Talk a little bit about what the impetus for that was and what that looks like.
Sure. The first thing to know is that nearly every administration since LBJ has either issued new guidelines or updated merger guidelines. The guidelines as we understand them first started to come into focus in 1968. And then the Reagan administration updated them in 1982. and again in 1984, and then 1992, and 1997, and 2010 under the Obama administration. And then at the tail end of the Trump administration, we see vertical merger guidelines. And so it was time to start thinking about how we assess mergers. And really what hastened our interest in updating the merger guidelines was a recognition that the economy itself had changed a lot since 2010, which was the last time we looked at the horizontal merger guidelines. And that's really important because you have to understand the ways that companies transact business in order to decide whether the competition at stake in a merger is actually meaningful and whether it is the kind of combination that should be swatted down under Section 7 of the Clayton Act. And so our Assistant Attorney General, Jonathan Cantor, asked us to do a really interesting exercise. He said, can you tell me how you assess a merger if guidelines didn't exist? And we accepted that challenge, and the staff started looking through the law, and the findings were really startling. What we observed was a really fantastic body of law that had built up over more than 100 years since the Clayton Act was passed in 1914. And there were very clear legal principles. It was very clear that looking through the legislative history of not just the Clayton Act, but the Steller-Kefauver Anti-Merger Act, it's right in the name, right? Congress was really concerned about mergers. And they were concerned about oligopolies, and they were concerned about the trend towards concentration and the idea that some mergers can really entrench or create dominance. And that is not really how the agencies had been enforcing the law, at least more recently, or thought about the law. I think we were more concerned about economic theories of harm, which are helpful too, but it also raised questions about analytical tools. And we got to work drafting an approach to the merger guidelines that reflected to the public how we think about mergers and how we apply the law and how we bring to bear the very best of analytical tools. And so again, if you are trapped in a paradigm that views competition as the type of competition that made sense in smokestack industries, you are likely to miss some of the real harms that are attendant to platform industries or to certain kinds of labor markets where we know that at lower monopsony power thresholds, you can start to see real harms that the antitrust laws are supposed to affect. And so before we actually drafted the guidelines, we issued an RFI and got 5,000 comments.
Wow.
And then after we drafted the guidelines and released them in July, we got 43,000 comments. And I think that speaks volumes. That says the public is interested. Yeah. The comments overwhelmingly wanted us to update the guidelines to reflect a more stringent regime for merger review. And it also told us the very real ways that Americans are experiencing monopoly power and market power. And their stories are really quite chilling. A lot of the comments are at regulations.gov. I urge you guys to go look at the emergency room doctors who talk about how care really declined after their practice groups were bought up, about maternity ward nurses who felt like they couldn't provide great care to brand new moms because after many rounds of hospital mergers, the requirements by their new owners did not allow them to round as much. By family farmers, retail worker. I mean, it just every industry was touched in some way with real stories about harm after mergers.
It's interesting because, I've always thought that you don't get change unless there's a real broad felt experience of the problem. And boy, is there that here. We all have an experience, I think, with monopoly power in one way or another. One of the things that has been a topic in many of the panels today has been coming specifically to AI. Is AI a new thing? Is it, should we think about it differently than we have other technologies in the past? And I want to actually read a quote from you, which I will then ask you to respond to, because you sounded off on the debate on AI today, generally assuming that AI is just its own self-contained product and not an extension of products and services that have existed for a long time and that are already markets that are good and consolidated. And then you added, I think it's just about leveraging or extending existing monopoly power, which is, that's pretty definitive. So say more about that. And what makes you feel like this is just more of the same?
Yeah. Let's take a step back and define what artificial intelligence actually is.
Okay.
It is principally products and services that are driven by computer or software intelligence rather than human or animal intelligence. And examples of it might include general internet search or web search, right? Google search, as most people have probably used. It includes autonomous vehicles. It includes the Waymo, for example. It includes voice-assisted search, right? Alexa and so forth. It includes things like generative AI and creative, like pictorial generated AI. And so on that sort of working definition of what AI is, it's pretty easy to see that these are products and services that we already understand. And so rather than imagining that this is a brand new paradigm or set of products, it really seems to exist within a technological continuum. And so we have a case downtown right now where we are litigating a monopoly concern with Google, right? We know how to bring to bear our antitrust tools on internet search. And so thinking about generative AI, which I think kind of sparked the public interest in what AI actually is, we know that some of the inputs that go into a generative AI product include things like massive data caches that have already been indexed. And so it stands to reason that if you already have a leg up in things like internet search, you are probably going to have a leg up in certain kinds of AI technologies. If you have a leg up in cloud computing, you probably are going to have a leg up again in new horizon AI technologies. And so, I worry sometimes that clever marketing and PR sort of makes these products seem new, but they are not in fact new.
It's a great point. Just as somebody covering business, it's amazing how, yes, there are some very advanced models of AI that seem like new business models, but there's a lot that you've been using it for years. It's really not that impressive. So, I take your point. Can you talk a little bit about using either Google or any other example, a little bit more about the structures and the legal arguments that you're going to try and deploy to deal with the AI issue?
Yeah, so I'll stay away from speaking too specifically about Google since that litigation is ongoing. But I think that AI gives us a chance to really reflect on the tools we already have, principally under the Sherman Act. So Section 1 of the Sherman Act condemns contracts, combinations, and conspiracies that restrain trade. And you think about, and I'm sorry, I should say Section 2 also is the monopolization section of the Sherman Act. And so it condemns full-blown monopolization, but also attempts to monopolize and conspiracies to monopolize. And so thinking about that, I think monopoly maintenance, leveraging of market power and an existing product seems to be a paradigm that could be very useful if we were to have a concern based on the facts and the law in AI. Another paradigm that I think is really interesting and a market structure we really need to pay a lot of attention to is information sharing. It's an area that I've spent a lot of time thinking about this year. The agency earlier withdrew certain healthcare guidance because, or in part, because there was a very permissive regime that seemed to permit information sharing up to a certain point, and gave a whole speech about it in February. Essentially, we learned that it was possible to maintain and sustain collusion under those frameworks. And so it's very important that we revised our guidance to the public because it no longer reflected our enforcement intentions. And so with information sharing, just a very simple example, if you have someone offering a product or service and they go out and collect their a bunch of competitors' competitively sensitive information, price, cost, et cetera, we would probably have a pretty good opportunity to use Section 1 to combat that kind of information sharing regime. particularly if there's an aggregated market power concern, and we see something that looks like effects, right? Higher prices or lower capacity as a result of that scheme. Now change the hypothetical. And imagine the person in the middle is not John. Imagine it is software, right? And there are private cases out there that really illustrate this principle very well. We need to be smarter and more concerned about how algorithms are using data and how companies are setting the objective function. I mean, one thing that's become clear is an algorithm is just software. Like the code itself is not all that useful. What is very useful is data, particularly the proprietary kind, and the objective function. And so as deep learning advances, one can imagine that these tools will get a lot better at efficiently colluding in a way that humans can't.
Interesting. Let me, we don't have too much more time, but I'm going to maybe go slightly over. Talk a little bit about some of the narratives that we've been hearing from the big tech companies, just in the public, about what AI can and can't do, what we have to worry about. Are there bits of misinformation, disinformation that you would want to particularly call out?
I think there's a lot of journalists in the room. I'm mindful that I'm talking to a business journalist. I will leave sort of scouting disinformation and misinformation to others. But I will say this. We at the Justice Department will not be suffering to disinformation and misinformation. So our Assistant Attorney General has prioritized hiring incredible data scientists and technologists, because we all understand that we need to understand what these technologies do in order to do our jobs more effectively. We brought on Laura Adelson, who is here. Laura, we miss you. Please come back. She did really incredible work in the year that we were lucky to have her, to make sure that as an agency, we were really set up to understand these issues. And then I would maybe caution more scrutiny about the claims that companies that either are already offering AI services or stand to benefit from the explosion of AI, and particularly how they think about regulation and antitrust. One thing we learned from sort of first frontier internet technologies and digital markets is that companies were very good at saying, don't use antitrust. That's the sledgehammer. Just regulate us. But I'm mindful that in 2022, something like $70 million was spent by the biggest companies. They blew their own records for lobbying. Bipartisan antitrust legislation did not pass in Congress. And so the argument seems to be, we want regulation, just not that regulation. And I think we should be careful about that. I'm really proud of the work that the department is doing to litigate the monopolization cases that we have against Google. And I expect that we'll still be busy on that frontier in the coming year. But it took us a long time to get there. And I think we can really learn from the ways that we experienced antitrust enforcement and concerns about monopoly and sort of first wave technologies, and make sure that we don't repeat those mistakes when it comes to new horizon or new frontier AI technologies.
All right, before I get the hook, I'm going to just read out one quote from Vice President Harris that I want you to respond to. She was speaking in London recently and said that even now, ahead of congressional action around AI and some of the tech harms we've been talking about, she said that there are many existing laws and regulations that reflect our nation's longstanding commitment to the principles of privacy, transparency, accountability, and consumer protection. These laws and regulations are enforceable and currently apply to AI companies. So what's the message to corporate America here?
That is a fabulous statement. I agree with it. I think that look, it's clear that it's clear from her statement that competition has a seat at the table. And I think that's reflected in the Biden administration's EO. And one of the things that I think that comment went on to address was concerns about preservation of our democracy. And I would say that we don't actually have to choose between competition and democracy. The folks that wrote our nation's antitrust laws understood that the value of competition as a first order benefit yielded myriad secondary and tertiary benefits, including the maintenance and preservation of our social, democratic, and political institutions. And I'm also, okay, I can't miss an opportunity to indulge in a little bit of legislative history, but we should be mindful that on the floor of the Senate, Senator Sherman, for whom our first antitrust law was named, declared that monopoly is inconsistent with our form of government, that it's a kingly prerogative, and if we won't have monopoly or king as a political power, we shouldn't accept it over the necessaries of life. And that if we wouldn't submit to an emperor, we shouldn't submit to the autocrats of trade. That's almost a quote.
The autocrats of trade. That is a good place to stop. Thank you so much. That was an awesome conversation. Next time I want more time. Whoever's got the time clock. Thanks again.
Thank you so much for having me.